Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus Associates in our Get Farsighted in 2020 complimentary webinar series. As you know, the FAR, Federal Acquisition Regulations, is the rulebook that the federal government must follow when making purchases. Our webinar series pulls from the contracting experts to explain each part of the FAR. It is complimentary and recorded. We'll post all of the recordings on our website and YouTube channel, where we have over 300 government contracting webinars available for download. A special thanks to our webinar partner in the series, the National Veteran Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us on our website. And now we would like to let you know about some ways to reach government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. Now let's move on to learn a bit about today's speaker, Devin Hewitt. You can find our contact information on the screen here. Today we are covering FAR Part 15 with Devin. Thank you so much for joining us today. We really thank you for your participation in the series. The floor is now yours. Please let me know when you're ready for your next slide.
Thank you. As the introduction indicated, my name is Devin Hewitt. I'm the senior partner at Pretoria Law, a law firm here in Tysons, Virginia. We're a full-service law firm. Our clients are primarily small businesses, and they're primarily government contractors. I myself am head of the government contracts practice, and I do protests. I, in fact, have done over 200 in my career. I also do contract negotiation, teaming agreements, subcontracts, joint venture agreements, non-disclosure agreements, pretty much any type of agreement. And finally, I do advice and counseling on FAR compliance, data rights, and other issues that typically come up in acquisition and government contracting. Next slide. Most of you are likely aware of how the Federal Acquisition Regulation is organized, because that's how these Jennifer Schaus webinars are organized. But I'll give a quick overview. The FAR, which is a United States regulation codified at 48th Code of Federal Regulations, contains 53 parts. And some of the examples are listed here. FAR Part 2 are the definitions. FAR Part 10 is market research. FAR Part 19 addresses small business programs. FAR Part 33 addresses protests, disputes, and appeals. The Jennifer Schaus webinar series has webinars on each of these. FAR Part 52 includes contract clauses and provisions. Contract clauses, as the name suggests, are those clauses that are included in contracts, but also will appear in solicitations. Provisions are provisions that the FAR instructs contracting officers to include in solicitations, but typically drop out once a contract is awarded. So, for example, they include instruction to offerors, instructions regarding representations and certifications. And FAR Part 53 includes acquisition forms that are used by the contracting officer in putting together solicitations. Next slide. There are various contracting methods identified in the FAR, and I list most of them here. FAR Part 6 isn't really a different contracting method, but it does identify the areas in which competition must occur. Frankly, all it really says is that there must be full and open competition. and that is implementing the Competition and Contracting Act, which is the foundation of government acquisition, and it provides authority for contracting on a sole source basis. FAR Part 6 is known primarily for the exceptions to competition, and one of those exceptions is contracting on a sole source basis, and one of the basis for that is small business set-asides. FAR Part 8 addresses required sources of supply and services. Those include sources such as federal prison industries and organizations organized primarily to help the blind, but it's most known for the General Services Administration's Multiple Award Schedule Federal Source of Supply Program. FAR Part 13 deals with simplified acquisition that primarily benefits small businesses, and that addresses acquisitions under the simplified acquisition threshold, currently at $150,000, and there are other thresholds as well that form the basis for more simplified, streamlined procedures. FAR Part 14 addresses sealed bidding, and sealed bidding is a contract award that is based simply on lowest priced bid. And that typically occurs in construction contracts where companies just submit bids and then there's a public bid opening and the contract award goes to the lowest priced bid. What we are going to talk about today is contracting by negotiation. And one other thing I should have included here was FAR Part 19. It is a contracting method because it is contracting within the small business programs administered by SBA, and therefore it includes small business set-asides or certain set-asides for certain types of small businesses, but it's not really different in that you can use sealed bidding or contracting by negotiation for those types of procurements. Next slide. What contracting by negotiation means, any method that is other than a contracting by the lowest price bid. However, contracting by negotiation does include lowest price technically acceptable, which is a bit unusual. The term negotiated refers to the ability of an agency to negotiate with offerors after submission of initial proposals through discussions. So negotiations and discussions are often used interchangeably. The purpose of contracting by negotiation is to make a contract award based on a proposal that represents the quote-unquote best value for the agency. And best value typically includes a trade-off between technical past performance and price, although low price technically acceptable is considered a type of best value award. This part of the FAR really addresses the life cycle of a competitive procurement. So FAR 15.2 addresses the drafting and issuing of a solicitation. FAR 15.3 addresses source selection, and that involves submission of proposals, the analysis of proposals, the identification of the competitive range, the conduction of negotiations or discussions, and the contract award. There's a separate section on contract pricing and different techniques to evaluate pricing. And then section 15.5 addresses notifications of award, protests of award, and mistakes discovered following award. Next slide. So the drafting and issuing of solicitations. The FAR encourages early industry exchanges to test the market and to gather information that would be relevant and helpful to an acquisition or an upcoming acquisition. And typically industry exchanges include industry days, market research, RFIs, pre-solicitation notices, many of the different actions that many of you are likely familiar with. What's important to note, however, is that responses to RFIs are not offers, and they cannot be, quote unquote, accepted by the government. Also, in terms of procurement integrity issues, after release of a formal solicitation, only the contracting officer is allowed to be the point of contact. And when we talk about procurement integrity, what we are talking about is the receipt of source selection sensitive information by one particular contractor, and therefore providing that contractor with some competitive advantage. Contractors are not supposed to receive source selection sensitive information that is not exchanged or not distributed to all offer awards. And in order to ensure that that happens, the contracting officer is supposed to be the only point of contact. Prior to release of a solicitation, however, contractors can talk to other people in the government, particularly technical points of contact, to distribute information or collect information. Now, the FAR prescribes certain things that must be included in a solicitation. The most important thing that needs to be included are factors and significant evaluation subfactors that will be used to evaluate the proposal and the relative importance of these factors. The second thing that must be included are obviously technical issues and the requirements. Everything in the solicitation, however, has to be included in something called the uniform contract format, and that's described in the FAR. The uniform contract format has 4 parts. The first part is the schedule, and that includes parts A through H. If you have ever seen a request for proposal or a solicitation, you've seen that they all have, as certain sections have alphabetical letters. Well, the schedule includes A through H. The second section are contract clauses, and that's section I, and the contract clauses will remain in the final contract award. Section 3 are the list of documents or attachments, and that is called section J. And then part 4 are the representation, certifications, and instructions to offerors, and that's sections K, L, and M. And once a contract is awarded, section or part 4, the reps, the asserts, and the instructions, sections K, L, and M will drop out of the contract. So the schedule includes sections A through H. Section A is the standard form 33. Section B is where you'll find the contract line items or the description of the supplies and services and the pricing for that. Section C is the statement of work or specifications. Section D will have packaging and marking instructions. Section E will include clauses regarding inspection, the government's right to inspect, and details regarding acceptance criteria. Section F will include information regarding deliveries or performance. Section G will include contract administration data, such as information regarding the contracting officer, information regarding appropriations data, invoicing. And Section H, which actually is a very important section, deals with the special contract requirements that are tailored to the acquisition and are tailored to the agency. Then Part 2 are the contract clauses, and Part 3, list of documents that are attached. The uniform contract format is important not only because it's uniform and because of the various sections in which drop out, it's also important because there is an order of precedence clause that says if there's an inconsistency among various sections and parts, that certain sections or parts take precedence. And that's important because, for example, there is some discretion, for example, what certain contract requirements will be in Section H versus the standard contract clauses which are included in Section I. Often there are also going to be clauses or provisions that are included in a statement of work which may contradict with something that is included in Section H or Section I. So it's important that the sections and the RFP is organized in this fashion because of consistency and also because of ease of reference for offerors, and finally for order of precedence and interpretation. With regard to solicitation amendments, if a contracting officer makes an amendment before the due date for initial proposals, the amendment needs to be sent to all the companies to whom a solicitation was sent. If an amendment is made after initial proposals have been submitted, then the amendment has to be sent to all the offerors that have not been eliminated. Now, if there is a huge amendment that would not have been anticipated by our offerors or changes the nature of the acquisition, the contracting officer can't really amend the solicitation. She or he has to cancel the solicitation and reissue it. Next slide, please. There are instructions in the FAR Part 15 regarding the submission and handling of proposals. Most importantly, the burden is on the offeror to submit its offer or proposal by the due date and at the address identified in the solicitation. Otherwise, it is late and will not be considered by the agency, and late is late, and this is strictly construed by the government and any agency, Board of Contract Appeals, or GAO, or in any protest. The only exceptions tend to be when the proposal is quote-unquote under the government's control but may not actually be received by the contracting officer or the office, or because the proposal can't be submitted because the government is shut down due to an emergency and the contracting officer hasn't had the opportunity to issue an amendment to the due date or the address. In that case, the due date for the proposal is the next day on which the government is open. And also there's an exception if it's the only proposal received. And the agency must inform an offeror if it considers a proposal late. There's always been a debate about what it means to be under the government's control in this day and age where most proposals are submitted electronically. I have actually been involved in a number of protests where emails have been sent but not received, are caught in the agency's firewall, etc. Let me just say that for the most part, those protests are denied. So it is very strictly interpreted. With respect to government procedures for handling proposals, the government is bound to safeguard the proposal information, and if it's unreadable, although that term is not defined in the FAR, the contracting officer is authorized to ask the offeror to submit a readable version, and when that submission is made, as long as it's made within the due date that is identified by the contracting officer, it won't be considered late. Now, I've never been in a situation where that has happened, and since unreadable is not defined, I can't see how that actually would be interpreted in a way that wouldn't contradict the otherwise late when late rule. Next slide. Now, FAR Part 15.3 is arguably the most important part of the FAR because it really discusses the whole timeline of source selection. The first part of it, and arguably the most important, is the requirement to include the evaluation factors and sub-factors in the solicitation. That is the basis of award, and the FAR says that the evaluation factors and sub-factors must be tailored to the acquisition. Price must be evaluated in every competition. The rating method is not required to be disclosed to the offerors. However, the solicitation must explain whether the evaluation factors are significantly more important than cost or price, approximately equal to cost or price, or significantly less important than cost or price. And this allows for a trade-off by the contracting officer between technical past performance and cost issues. And it allows the government to accept other than the lowest price proposal, but the perceived benefit to the government of the higher price proposal must justify its cost. So that's known as the best value cost technical trade-off, and is what distinguishes FAR Part 15 procurement from FAR Part 14 procurement. As I said, the low price technically acceptable method is considered a form of best value because a contracting officer can make the judgment that acceptance of certain technical factors and reliance on a low price is a type of best value for a particular type of acquisition. One thing to note is that the FAR does say that the source selection authority presumptively is the contracting officer. And most people aren't aware of that, although I've seen actually in DoD procurements that often other higher authorities are made the source selection authority. With regard to proposal evaluation, the agency is only supposed to evaluate a proposal based on the factors and sub-factors in the RFP. But the agency must identify the relative strengths, deficiencies, significant weaknesses, and risks in the proposal. And any rating method may be used. With regard to past performance evaluations, the government can consult other sources. The government will take into account the former companies of an offeror or former personnel, as well as subcontractors proposed by the personnel. If a company does not have any past performance, the FAR instructs the agency not to use this as a disadvantage or to score the offeror negatively under past performance. That offeror is simply supposed to receive a quote-unquote neutral past performance rating. And the FAR says that the solicitation should include a past performance factor in which an offeror's compliance with past small business subcontracting goals is a feature of the past performance evaluation. In a negotiated procurement, a agency or a contracting officer can award a contract based on initial proposals. However, the RFP has to say that the agency is thinking about doing that or can do that. If the RFP doesn't say that, then the agency must establish a competitive range. And a competitive range is supposed to include those most highly rated proposals, unless efficiency dictates otherwise. So the agency is allowed to reduce the competitive range to that number that is most efficient for the agency, and it doesn't have to be a particular number. Now, before the agency sets a competitive range, it may have exchanges which are defined as communications with offeror that are characterized as clarifications. After the agency establishes a competitive range, those communications are called discussions. And the nature of communications and the way they're characterized are very important. Because if an agency has communications that are characterized as clarifications, then the agency does not have to establish a competitive range and does not have to allow offerors to submit revised proposals. A competitive range and the conduct of discussions is done with the intent to allow offerors to submit revised proposals. So again, the characterization of communications after the receipt of initial proposals is very important and often the subject of protest. So what is a clarification? A clarification is a communication between an agency and an offeror that addresses minor clerical errors or some item of past performance. Generally, it raises an issue of adverse past performance to which the offeror may not have had a prior opportunity to address. So in those areas, the agency may reach out to a contractor to say, did you know about this unsatisfactory rating? Or did you forget to submit this past performance rating? Or did you intend to leave off these zeros? Or did you not include this acknowledgement, etc.? So they're minor issues that don't really affect the offer per se, the terms of the offer, but are administrative or clerical. Most importantly, they do not require the offeror to provide additional information that would amend the terms of the offeror. It may clarify something, but it doesn't require the offeror to provide additional information that would change the nature of the proposal, because then that is really characterized as a revised proposal submission, and that cannot be made only to one offeror. What are discussions? Discussions are substantive areas in which the agency must raise deficiencies or significant weaknesses in an offeror's proposal, or areas in which the offeror may materially enhance its proposal such that it will increase the likelihood of success for award. And if discussions are conducted with one offeror, they have to be conducted with all offerors. Now, that doesn't mean they all have to be the same. They don't all have to touch on the same issues. The discussions are supposed to be tailored to each proposal, and they're supposed to identify the significant weaknesses and deficiencies in each proposal, which obviously aren't going to be the same for each proposal. So once you have discussions, they're supposed to be such that they're tailored, and then the agency is supposed to allow all the offerors to submit revised proposals addressing the items that were raised in discussions. There's often a debate about whether offerors can change other items in their proposals that weren't raised in discussions, and the conventional wisdom is that if issues that are related to what is changed, for example, if you are going to change key personnel or personnel because the initial proposed candidate doesn't have the qualifications, but you have now a new candidate that candidate costs more money, well, then you should be able and should submit a revised cost proposal to reflect that additional cost. But should you or are you allowed to submit a revised cost proposal or price proposal independent of anything you do in your technical proposal? Well, the FARS says revised proposals. It doesn't specify the nature of the proposal. So ideally, you should be able to submit any type of revised proposal following discussions. Now, source selection is made by, as I said, the contracting officer or somebody else delegated by the contracting officer or the head of the agency. The purpose of source selection is to do a comparative assessment of the offers that have been submitted, and the source selection decision must reflect the independent judgment of the source selection official. The source selection decision must be documented, but there isn't a need for the documentation to reflect a quantification of the superiority of a higher priced but higher rated proposal. So what that means is if you've got a higher technically rated proposal and a higher price proposal, you don't have to say that the higher rated proposal is worth the $50,000 more, or that the technical quality is equal $50,000. You don't have to quantify in dollars the additional technical value that balances the higher price. Next slide. FAR Part 15 includes a whole separate section on contract pricing and evaluating price proposal. The FAR's pricing policy is that the objective is to obtain fair and reasonable pricing for the government, assuming reasonable economy and efficiency. Now, there are different types of proposal analysis identified in FAR 15.4. There's price analysis, cost realism analysis, and price realism analysis. There's also something called unbalanced pricing, which is a type of pricing analysis. Pricing analysis has to be done in every procurement where there is price or a fixed price offer that is required to be submitted. Usually adequate competition, quote unquote, establishes price reasonableness. The two preferred types of price analysis identified in the FAR is adequate competition, and that involves merely a comparison of the various bids that have been submitted or proposals, offers that have been submitted in the competition, or looking at historical pricing of incumbent offers or similar offers or contract prices that have been submitted or awarded in similar acquisitions. And that typically can be all factored into an independent government cost estimate, an IGCE, and then they're actually done often in fixed price contracts too. But for the most part, determining about whether or not a price is reasonable, that's usually perfunctory, and where there's a competitive procurement and price reasonableness is the only issue. What often happens, though, where there's a contract award and offerors believe that contract award is based on what they believe to be an unrealistic low price, they will protest saying the price isn't reasonable. The authorities who rule on protests, however, have interpreted the term price reasonableness to mean that the price that was submitted was not too high, not too low. The term price realism is an analysis that assumes or looks for whether or not a price is too low, and we'll get to that in a second. The second type of analysis that's identified in the FAR is cost analysis, and that applies where cost proposals are submitted. And a cost analysis is one in which the reasonableness of individual cost elements are looked at, and that requires the application of judgment to determine how well the proposed costs for these individual cost elements represent what they really should be in the context of the procurement. A cost realism analysis must be identified in a solicitation that the government is going to do it. And it is required in cost reimbursement contract cases and when there's going to be cost reimbursement offers. Now, what a cost reimbursement analysis looks at is, one, what the government will realistically pay if it makes an award based on that proposal, whether or not the offerer really understands the scope of the work or the nature of the work, and the offeror's ability to perform the work. And taking all these things into account, the government comes up with a quote-unquote a probable cost of performance, which reflects the government's best estimate of what it thinks it will cost if it makes an award based on that proposal. And the government is supposed to use that probable cost for purposes of evaluation in the procurement. Price realism is a form of cost realism that is applied to fixed price proposals. Now, this term, price realism, is not specifically named in the FAR, although the FAR does say cost realism may be used for price proposals. The term price realism has to be used in a solicitation in order for an agency to have the authority to use that type of analysis in a source selection. And what it is the application of cost realism to fixed price contracts to determine whether the price proposed is too low. Unbalanced pricing is a type of price analysis, and it's used to assess risk. It occurs when there's an acceptable overall price, but the price of one or more line items is significantly overstated or understated. So, for example, where there are startup costs for, let's say, a construction, and you have to buy all this equipment or materials, and all those costs are in the first year instead of being amortized over all the years, that may mean that the government pays all those costs in the first option year or the base year, and if it doesn't exercise all the options, it's stuck with all those costs even though it didn't realize the benefit of the whole period across which all those costs could have been amortized. This section of the FAR also addresses certified cost and pricing data. What is certified cost and pricing data? Certified cost and pricing data is data that the offeror certifies in writing to the government that is current, accurate, and complete. It does this when it submits information that is going to be evaluated and reviewed by the Defense Contract Audit Agency. And it has to be submitted in order to have its accounting system be qualified. And so it is a very complex and high level of specificity with regard to the information, and it is high risk for a contractor. Most small businesses don't have this type of sophistication in their accounting system, and FAR 15.4 generally says that contracting officers should not require this type of data in procurements where there's going to be adequate price competition, in procurements for commercial items, and procurements less than $750,000. And for the most part, contracting officers do ask for what something known as other than cost pricing data, and that's usually price price in accounting systems to support burden labor rates, G&A, overhead, etc. Next slide. The FAR includes, this part of the FAR includes information about what happens after an award or a source selection. There can be pre- and post-award notifications. Pre-award notifications generally occur in two instances. One is in small business set-aside procurements. In that instance, before award of a contract to a small business, the agency is supposed to issue a notice to all offerors in that procurement that identifies the apparent successful awardee. And that is to allow enough time for the other offerors to protest the size or status of the apparent awardee. And the other offerors have 5 business days to do so following receipt of the notice. The other type of pre-award notice is when the contracting officer has excluded an offer from the competitive range. Debriefings are offered to offerors, again, both pre- and post-award. An offeror that is eliminated from the competitive range may receive a debriefing at that time or can postpone the debriefing until after contract award. However, that offeror cannot have both. It has to choose, and if it waits for a debriefing following contract award, it creates a risk that the issues that it raises from that debriefing in a protest following a post-award debriefing, those issues may be considered untimely because they could have been raised in the pre-award debriefing following its exclusion from the competitive range. The post-award debriefing occurs, as it indicates, following award, but an offeror must request the debriefing within 3 business days following 3 calendar days following receipt of notice of the award. Now, one of the big issues is what's included in a debriefing. The debriefing must include significant weaknesses and deficiencies that the agency identified in the proposal, the overall cost, price, or technical rating of the successful offeror, the overall ranking of offerors, if there was one, a summary of the rationale for the award, and answers to any questions or reasonable questions by the debriefed offeror. With regard to civilian debriefings, there's always been a question about whether, if questions are raised following closing of the initial debriefing, whether that extends the time for filing a protest in which an offeror can get a suspension of the award called a seek a stay. That seek a stay can only be triggered if the protest is filed within 5 calendar days following the closing of a debriefing. But the closing of the debriefing is not clear in civilian procurements, particularly if questions are asked after the closing, because the questions and answers could occur some days afterwards. DOD, however, has addressed that and has specifically says if an offeror submits questions within 2 business days following the close of the initial debriefing, the CICA 5-day rule doesn't start until the DOD agency provides answers to those questions. So that's been clarified. With respect to protests, that is actually addressed in FAR Part 33. There are generally 3 types of protests: protest to the agency, protest to GAO, the Government Accountability Office, and protest directly to the Court of Federal Claims. The FAR says in this section that if the agency has to go back and issue a new solicitation or revised proposals are required as a result of protests, then the agency should disclose to all offerors the information that may have been disclosed to some of the offerors that had requested a debriefing. And with respect to mistakes that are discovered after an award, they may be corrected if the mistake results in correction that's more favorable to an agency, or an agency may reform or rescind the contract, reform meaning they can delete items or increase the price, if there is clear and convincing evidence of the mistake and the agency agrees and it thought it was a mistake, or the mistake was so apparent as to have charged the contracting officer with notice of the probability of the mistake. And finally, the FAR addresses something called unsolicited proposals. Unsolicited proposals are exactly what it sounds like. It's proposals that are not responsive to something the government has issued, whether it's a CBER procurement or an RFI or a pre-solicitation notice or a field bid, etc. And typically, unsolicited proposals are innovative and unique. They must be independently originated and developed by the offeror. They are prepared without government supervision. They have to include sufficient detail to demonstrate the benefits to the agency. And they typically represent substantial investment already made by the offeror in their unique and innovative concept. The agencies must have procedures for the receipt, acceptance, and the evaluation of unsolicited proposals that are made public. And finally, agencies are prohibited from releasing proprietary and confidential data included in unsolicited proposals. That's it for FAR Part 15. And if you have any questions or would like to follow up with me on these issues, my contact information is in the last slide. Thank you for your time.
All right. Thank you so much for a great presentation, Devon. To our audience members, thank you for participating with us. And if you have any more questions about this part, please contact our speaker with the contact information you see on the screen. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. This concludes today's webinar.